Welcome back to the afternoon session of the August 3rd, 2021 Lane County Board of Commissioners meeting. At this point, we are on item number 13, Public Works. Item 13A is the fourth reading and deliberations for ordinance number PA 1385 in the matter of amending the Lane County Rural Comprehensive Plan to add a quarry to the inventory of significant mineral and aggregate sites, authorize mining and processing as provided by Oregon Administrative Rules 660-023-0180, amending the RCP to redesignate land from forest to natural resource, mineral and rezone that land from non-impacted forest land F1 zone to quarry and mine operations QM zone, requiring site review of the proposed mining operations pursuant to Lane Code 16.257(4)(a)(J), repealing ordinance number PA 1363 and ordinance number PA 1343, and adopting savings and severability clauses, remand number 2, planning file 509-PA20-05535, remand number 1, planning file 509-PA18-05392, original planning files 509-PA15-05803 and 509-PA15-05804, applicant Old Hazeldale Quarry. And we have with us Deanna Wright, who will provide a staff report. Excuse me, before and Deanna provides that report, I'm to call for disclosures of board ex parte contacts, conflicts of interests, or biases. So first, are there any board members who feel they must abstain from taking part in this proceeding due to conflicts of interest or biases? Commissioner Bozovich, the last time that we held this, you were not here, and commissioners disclosed if Ed King had provided them campaign contributions. So I'll give you this opportunity. Each commissioner reflected on that and said that would not bias their decision in any way. I'll give you that opportunity, sir.
I was going to disclose that when you asked for ex parte contacts and all that. Yeah,
that.
Sure.
Okay,
Yeah. Ed King has been a past contributor to my campaigns, and I've sat on land use decisions of other past contributors. It has not affected my ability to make my decision based on the criteria, not on the applicant. So I don't believe that will color my decision. I also just want to declare the ex parte contacts past the close of the record from various people by email lobbying us to support or not support the decision in one way or another. And I have made a point of not taking those into account once the record was closed. As far as the decision, most of them really haven't addressed criteria anyway. So I'll just state that I have received contacts post close of record.
Thank you, sir. Item B, are there board members that wish to, sorry, I jumped the gun on you there, Commissioner. Are there board members that wish to disclose any ex parte contacts? And if so, do such contacts preclude the board member from acting impartially? I would like to declare that I had an ex parte contact in that I called the mayor of Oak Ridge for directions so that my wife and I could drive out there and take a look and survey the scenery. In no way will that preclude me from acting impartially. Are there any other ex parte contacts? Commissioner Farr.
I'll just say that apart from what Commissioner Bozievich just mentioned regarding the public emails, I received one personal message from not a constituent, but from an individual who had an opinion. It will not affect my decision making.
Thank you very much, Vice Chair. Okay, excuse me. And finally, are there any challenges from those in the audience to the board's authority to hear this matter? Diana, is anyone indicating?
This was not a meeting where we had people sign up to speak.
Okay.
So no.
Okay, well, this was on my list of things to call for, so I apologize. Ms. Wright, at this time, could you provide us a staff report?
Good afternoon, Chair and Board of Commissioners. I'm trying to share my screen with you. Are you able to see the PowerPoint presentation and hear me clearly?
Yes, we are.
Okay, great. And I'm trying to do the proper presentation, so I'm not wanting my staff notes to be seen. So if they are shown in this presentation, please let me know and I'll try to convert to a different PDF. So good afternoon.
Could chime in, but I don't see any notes.
Okay, great. Good afternoon, Chair and Board of Commissioners. This is Staff Deanna Wright. The supplemental memo was published to the board's agenda webpage and the Hazeldale Remand Project webpage on July 28, 2021 for the board and the public to access. During the last continued public hearing on May 4th, 2021, the board motioned to close the public hearing, but kept the record open with the following dates. May 18th, anyone may submit additional testimony. June 1st, anyone may respond to new evidence, and June 8th, applicant's final rebuttal was due. After each close of record, staff forwarded the items to the board and published the testimony to the project webpage just due to the large amount of submittals. Today, we're here for deliberations on the application on remand from LUBA. The supplemental memo covers three options. They are approve, reopen the record, or deny the applications on remand. The main question is, are there conflicts? Minimize. The OAR, Oregon Administrative Rule, directs this in subsection 5C, and then defines what conflict minimization means. Conflict minimization means to minimize the conflict, to reduce an identified conflict to a level that is no longer significant. Based upon testimony received during the open record period, the remaining issues include: 1, big game habitat conflicts; 2, silica dust and air quality conflicts; 3, conflicts resulting from groundwater vibration caused by blasting; and 4, scope of groundwater impacts. On the following slides, I'm going to touch on these individual issues. But first, before we get into the key issues, we wanted to broach this initial request of reopening the record. While staff is not making a formal recommendation on this matter, staff believes it's the board's discretion to discuss reopening the record at this time. Excuse me. Staff are aware the applicant is working with Oregon Department of Fish and Wildlife, which would take some additional time to complete and submit a habitat management and mitigation plan. If the motion is to reopen the record, then it makes sense to cease staff presentation and carry over the remainder of the deliberation discussion to a subsequent reading and deliberations after the record has been closed. However, if the motion is to not reopen the record, then staff is ready to proceed with the staff report. Again, staff note, we're aware that meetings and discussions have taken place between the applicant and ODFW, and progress is apparently being made on a HMMP. So at this time, we respectfully ask, does the board wish to reopen the record? And this is something that your group, you can talk about now or wait till the end of the presentation. It's up to you, your group, the board.
Commissioners, I'm of the mind to hear the whole presentation first. I don't know how you feel. Commissioner Farr.
Just a question. I'm fine with your decision on that, Chair Bernie. But so we have a decision to whether or not to reopen the record. And Deanna, why would we want to reopen the record? Tell me the reasons we would want to reopen the record. Now they're written down here. I'd like to hear it verbalized. Thank you.
We received a request from the applicant to request to reopen the record so that they can develop a habitat management and mitigation plan with Oregon Department of Fish and Wildlife. So the purpose of that plan would be to coordinate that plan to minimize the conflicts with big game. So it'd be between those two groups, the applicant and Oregon Department of Fish and Wildlife. We can't accept that plan right now because the record's closed. So that's why they're requesting to reopen the record.
Thank you. That very succinctly puts it, gives us the reason that we would want to reopen the record. And I guess as we move forward with this discussion, I think if a plan is in process, and it sounds as though a plan is in process to present a response, I don't know why we would not want to hear this until the end. Thank you.
Sure, thank you.
That is to say, I cannot see why we would not want to reopen the record and allow for the continuation of the plan that is already in process.
What? Oh, okay. Well, it sounds like commissioners want to respond. So go ahead, Commissioner Buck.
Well, this is more of a process question, two of them actually. First is, if we reopen the record, for how long is the record reopened and for whom is it reopened for? The second process question is, if we decide not to reopen the record, it seems like we don't need to go through the rest of the staff report because we would then wait until a later date in order to get all the information provided at one time. Those are my questions, Chair.
Deanna?
We don't really have a date to close the record if it's opened. We did kind of initially discuss a few dates. Those are, I don't have them right in front of me.
If this is Andy Clark, if I can jump in real quick, Deanna, the date that staff was considering, if the board wants to reopen the record, that would be done on or before, I guess, August 31st of this year, and then for the purpose of allowing in a habitat management mitigation plan, presuming that there is one at that time for submission. And if there is, then any motion and order by the board to do that should also include a time period thereafter for responses to the plan, since nobody's seen it yet and opponents and other folks should have a chance to look at it. And that can be, I think, reasonably anywhere from 2 to 4 weeks at the board's discretion. At least those are the dates that we have discussed.
So thank you, Andy. Does the board want to hear this whole presentation? Do you want to just stop here and go over this? Commissioner Buck?
I think we should stop here and go over this particular issue. It seems like if we're going to go through the whole presentation again later, if the board decides to reopen the record, in which case we'll go through this exercise twice. So it seems like we have a poignant decision to make at this particular moment.
Fair enough. Do any other commissioners want to weigh in on this? Yes, Commissioner Bozevich.
I kind of had concerns the other direction somewhat. If in the other three items, they fail to meet the criteria, there's no point in reopening the record for this one if we were going to deny based on the other three. So I guess maybe if staff would may be able to quickly tell us whether or not they feel, that the criteria for mitigating the impacts and all that apply in those other three, or whether this is the only one that's really in question and has a possibility for reconciling by reopening the record. But if the other ones are, negative and we're going to deny anyway, then there's no point in opening the record over this and then ending up in denying. That's kind of why I was hoping we could hear everything first.
Some commissioners would like to stop now, and one commissioner would like to hear the rest. Deanna, can you, in a few minutes, go through the rest of these options so that we can then engage in discussion and debate?
Sure. Do you just want me to chat about them or go over on the slides?
Well, I think answering Commissioner Bozevich's question would probably do.
Okay. So it does appear that the only key issue and dispute that remains is the big game habitat conflicts. The other three items appear to have met criteria through conflict minimization through either conditions of approval, specific conditions of approval, or best management practices. And there are specific conditions in the conditions of approval and best management practices that relate to each item 1 through 4. But yes, the only item that remains unanswered, in our opinion, is the big game habitat conflict.
And real quickly, if I might, Andy Clark again, and I should stress that's staff's opinion and recommendation at this point. Obviously, whether or not the other 3 identified conflicts have been satisfied is of course up to the board, and we're happy to discuss that more in detail, but that's where the staff has come down at this point.
If I may, Andy Clark, over the weekend when I was reviewing the materials for this, what I reviewed said the staff recommended option 3, denial of application. Has something changed in the last couple of days?
That, and Deanna can correct me if I'm wrong, but that recommendation is presuming that no more evidence comes into the record. In other words, if the board decides not to reopen the record and review a plan of any sort, then staff thinks that currently the evidence in the record doesn't show that the conflict with big game habitat has been minimized, and therefore that could be a basis for denial.
So my question is that the staff recommendation or not? Because I read that it was, and I'm hearing that it's not.
It is pending your decision on reopening the record. If you decide that you want to take a look at the mitigation plan, then I think staff won't have a recommendation because, of course, we haven't seen that plan. We'd have to review it and give you our recommendations, whether that plan satisfies, in our view, what the rule requires for mitigation of conflicts or not.
So you don't have a staff recommendation?
Yes, we do.
Okay.
Yes. So at this point, staff is still recommending denial. And again, that's because we believe that the record does not have sufficient evidence to get to positive findings for conflict minimization for the big game habitat conflicts. And that's based off the Oregon Department of Fish and Wildlife comments that were submitted into the record in April and in May that really called into question in our understanding, whether or not those conflicts have been sufficiently minimized. So
there
we're
is
not
a
changing.
recommendation. Okay, that's all I was asking.
Yes, thank you.
Other commissioners? Yes, Commissioner Farr.
Thanks, Chair Bernie. And, respectfully saying this, staff's changed their mind several times as we receive more information. So at this point in time, before we have the discussion, results of the discussion between ODFW and the applicant, we don't have the full amount of information. So I think really I personally believe we owe due diligence to the process to reopen the record in order for that discussion to occur, so that it's not just the opinion of staff that the conditions are not going to be met, that it becomes actual fact that the conditions aren't met. I believe, due to the length of this process that we've been going through on this particular issue, on this particular ordinance, I personally believe we owe the full fruition of the discussion. And as long as the applicant has an opportunity to meet the criteria, I believe we should allow the applicant to demonstrate that. Otherwise, some people are going to feel that they have been short-circuited in their attempt to provide all of the information. Ms. Wright said that there is a process in place with ODFW and the applicant right now. I believe we should let that process come to fruition and then make a decision based upon a full set of information, a full set of data, as opposed to what appears to be, or what some people would believe is, an incomplete set of data.
Thank you, Commissioner. Commissioner Trieger.
Thank you, Chair. Just, yet more process questions, because that's really what this is all about, right? That's what this hearing is making sure the process is integrous. If I'm understanding, if we were to deny, then if we were to leave the record or reopen the record, it leaves space for a habitat mitigation plan to be presented. If we're to deny based on impact on big game, then that could still come back to us, and then such a plan could be presented in response to that denial, or is that not so? I'm asking staff because I think, there's sort of three levels here, right? There's LUBA, there's our staff, and then there's the Board of Commissioners. In that order, in terms of training and technical expertise in understanding land use law, and in, for lack of a better word, in being arm's length from any particular investment in an outcome one way or another. And so I'm asking staff for that because they're the ones that are far more trained and versed in the various subtleties of land use law and code than any one of us commissioners. Nobody on this commission has that same level of expertise. None of us are professionals in land use planning or management.
I'll take a shot to the extent that I understand the question, but if what you're asking is whether there's an opportunity to introduce the management plan after the board has made a decision on the application, I think no would be the answer. The board needs to make a decision on this application, and then the parties have rights to appeal, which they are not reluctant to exercise, as we've seen. There's always the possibility that if the application is denied and that denial is eventually affirmed by LUBA, the applicant could refile at some point at a later date, a year down the road or more. But for practical purposes, the time to look at a management plan on this application is, sort of now or never, basically.
Thank you.
Before we go with commissioner comments, Mr. Mokrahajski, did you want to?
Well, my hope was just, I sense maybe a slight lack of clarity around, or potentially misunderstanding. I don't know if it's a misunderstanding. So I just want to be clear about the decisions here, and Ms. Wright and Mr. Clark can correct me if I'm wrong here. There are two potential decisions. The first decision by the board is whether or not to reopen the record. There's not a staff recommendation on that decision. You asked if there's a staff recommendation or not. There's not a staff recommendation on reopening the record. That's the board's decision. That's your first decision. If you choose not to reopen the record, then your decision is either to approve or deny, and that's where the staff recommendation is coming in based on the record that's been submitted. So I just want to be clear about, I know there was, what's the recommendation? There's not a recommendation on reopening the record. There is a recommendation if you choose not to.
Well,
That's correct for my plan as well.
there were commissioners' hands, but would not the decision to deny by definition not reopen? And is that not, and my question was, what the hell is the staff recommendation? That's all. Understanding no matter what happens, there probably will be appeals. Did you want to clarify that, Steve, or no? Or can we continue with commissioner questions?
Well, if it needs clarity, so Ms. Wright indicated the staff recommendation, if the decision is not to reopen the record, is to deny the application based on the information that's been submitted. But the first question, as I understand it here, is whether or not to reopen the record.
Thank you.
Does that help? I'm not trying to make it muddier. I'm trying to clarify. Hopefully that helps.
I think we all are, and thank you for the collegialness, everyone, of this. Commissioner Buck, did you have your hand up?
I was only going to mention the same thing that you mentioned, Chair, which is no matter what happens here, either party will most likely appeal. So, we make our best effort to go through thousands of pages of documents on this particular application, but ultimately something's going to be appealed, and eventually over time LUBA will address them as they are appealed back to them, and so no matter what we do here today, this is not the end of this particular item in our future. And as much as I would like to try to find a way to come to a conclusion as fast as possible for the sake of the applicant as well as the sake of the community who is waiting with bated breath as to what we are going or not going to allow in their community, I just want to make sure that people are aware that this is most likely not the final call, no matter what way we go.
Thank you, Commissioner. I saw both Commissioner Bozevich and Commissioner Farr. Did one of you want to? Commissioner Farr is pointing at Commissioner Bozevich, I think. Not on my screen, but.
Yeah, that was pointing off screen for me.
Commissioner Bozevich?
I just want to take some exception to Commissioner Trieger's comments about the amount of expertise of this board in land use. I spent a 29-year career in land development and worked intimately with Oregon's land use laws. I've worked with the attorney that, heard Supreme Court cases, argued Supreme Court cases on property rights relative to Oregon's land use laws and won. I've been an expert witness in land use decisions, qualified by the courts. I kind of take exception that for some reason staff might, there may be a few staff that are at my level of expertise, but there are not many that have more than 30 years experience working in land use. So just be aware of that as you make those kind of comments. This is my field of expertise.
Commissioner Bozevich, did you want to speak to this item or not at this time?
At this point, I fully understand the options that are available to us. We, like Commissioner Farr said, we do have the ability to reopen the record and allow the applicant to work on getting a big game habitat management plan in and a mitigation plan, which I think would benefit everybody time-wise. because if we do go through a denial, that either starts an appeal process of that denial, or it starts a reapplication process for the applicant, because it's not, they can't just come back with just that item and address only that item. They have to start over with the application process from the very beginning. And how many years there were other commissioners on this board the first time we heard this case? So it's been around for almost 4 or 5 years now. Waiting another several months to go through a delay to possibly resolve this permanently and find out if they can get past the big game conflicts, I think would suit everybody. As you know, one of the things this comes before the board is because it is a Goal 5 resource we're dealing with right now, as is the big game habitat, and there's conflicts between them, and we're trying to resolve those. But aggregate is an important, resource for our communities. Every house built, every road built has aggregate involved. And distribution of aggregate resources throughout the county saves transportation cost and footprint. And I just think it would probably be beneficial if this board considered reopening the record and trying to deal with this issue, rather than just going straight to a denial and then having to deal with either appeals or reapplication process for such a needed resource. That's my thoughts. Is I kind of lean with Commissioner Farr, Vice Chair Farr, on reopening the record and allowing a submittal of a big game habitat management plan.
Thank you, Commissioner. And the commissioner that he's leaning with, Commissioner Farr.
Thank you, Chair. And what we could do is, with a motion and a vote right now on whether or not to reopen the record, really kind of settle the matter. I've stated that I believe we should listen to the mitigation plan, and that we should hear that. Based on that, I'd be prepared to make a motion to reopen the record. And the reason is, if we vote this down, if the majority of this board votes down the motion to reopen the record, the final motion of the day, it seems to be kind of a moot point, that it'll be a denial. So this is the precipitory vote as to whether or not we're going to deny, or whether or not we allow more evidence to be presented to potentially alter the final vote. So with that, I'm prepared to make the motion to reopen the record. But I'm not going to do it in a bully fashion.
Well, then, with your permission, Commissioner, I know I wanted to say a few words, but perhaps other commissioners do too first. Do any other commissioners have any other? Okay. Well, then you're only one person away from making the motion. My feeling is, well, first, did not this body vote to close the record the last time we dealt with this? And was that not the staff recommendation at the time? I know this body voted to close the record. Deanna, did we do that prematurely? Because that was this body's recommendation.
Correct. The record was closed. I don't think it was premature. First time we saw the request for the hazard mitigation plan was, I believe, the applicant's June 1st submittal letter, and then their June 8th final rebuttal is when they actually requested to reopen the record for the purpose of the hazard mitigation plan coordination with ODFW staff.
Thank you. It's interesting because actually my recollection is that we had a rezoning of non-impacted forest land zone to quarry and mine operations once before that I voted for. And I remember that vividly because we were meeting in person then. Commissioner Bozevich, the resident expert on land use, was to my left. And we were going over things, and I learned quite a deal, and I really miss in-person meetings. That's just one reason. But on this one, here's why I'm feeling different than I hear some people saying. My understanding is this process has been going on for apparently 4 or 5 years. I vividly remember the applicants saying they had sufficient evidence in the record to approve at our last meeting. And now I'm hearing there is not sufficient evidence in the record to approve. And this has been going on a long time. And let me just share, you know, my experience with the residents of the Patrician Manufactured Home Park, now the Filbert Grove Cooperative, really brought me in touch with the level of anxiety and angst when there's an indecision and uncertainty that goes on and potentially impacts residents. Obviously, that was a fundamentally different thing. But I know that angst is occurring, and I know no matter what decision of this body, it will continue to occur because I firmly believe, as Commissioner Buck stated, that either side will appeal. But my feeling is, and this is the reason I kept pushing on this, asking about the staff recommendation, so much staff time has gone, you talk about efficiency of resources, so much staff time has gone into this. We actually do have a recommendation. We did, as a body, close the record. That's why I asked if we did that prematurely. We did close the record. And now it seems that with a recommendation, I even inquired from staff, I mean, is more time usually, does it become prejudicial? I mean, do people really, what goes? And what I've been told is all it does is cause it more and more difficulty for staff to make a recommendation. So I'm willing to be wrong here, and I'm willing to listen to arguments, but my inclination is to go with the staff recommendation at this point in time. And I'm someone that voted enthusiastically for the very reasons Commissioner Bozovich just mentioned, for approving a quarry in mind that was closer. But this one and the issue of big game habitat, which has not been adequately addressed, concerns me. There have been years here. So that's kind of where I am. And with that, unless there are other commissioners that want to make other comments, Commissioner Farr.
Thanks, Chair Bernie. And the one difference is that there is a process in place right now that will precipitate a set of findings between the applicant and ODFW. That wasn't there to my understanding, or I hadn't noticed that it was there when we made the recommendation to close the record. So that being said, I believe that by reopening the record, we're going to put everything to rest ultimately, and in the shortest possible number of weeks. So my motion then is to reopen the record for the purpose of accepting a draft habitat management and mitigation plan to be submitted on or before, and Mr. Clark, think about this because I need you to insert dates there, on or before such a date.
Commissioner, I'm sorry.
Submitted, reopen the record until they be specified to allow for the submission of response testimony to the draft management and mitigation plan. It's once get specified. And in this understanding, my motion.
And I apologize, Commissioner. Your iPad took a bad time to freeze. So we heard part of that. I'm so sorry.
Thank you. Am I clear now?
Yes, you are, sir.
Then I move to reopen the record for the purposes of accepting a draft habitat management and mitigation plan to be submitted on or before a date specified by staff, by the applicant. After the draft habitat management and mitigation plan has been submitted, reopen the record until a date specified by staff to allow for the submission of response testimony to the draft habitat management and mitigation plan, and to set a fifth reading for deliberations and a tentative decision for, once again, a date specified by staff.
We heard every word, Commissioner. Thank you. Commissioner Farr has moved.
I will second.
May I paraphrase and just say reopening the record?
That's good with me.
And
it is in our
yes.
So.
And Commissioner Bozievich, thank you, sir. And Commissioner Bozievich has seconded. Is there discussion to the motion?
This, if I might, this is Andy Clark, if I can weigh in real quick. I just wanted to, I don't know if it's a correction or not, but at least emphasize the fact that the mitigation plan concept was initiated, I think, actually by ODF and W as part of the letter that they submitted, I think, during the open record period, where they have identified the conflicts that sort of lead us to where we are now. And the applicant's position at that time, as they indicated to you in their final rebuttal, I think, is that that issue and that letter came up very late in this very old process. And that's one of the reasons they're asking for the record to be left open. I think, Chair Bernie, you've identified sort of the strong reasons why that's troubling to reopen the record. On the flip side of it, from my standpoint, there's not a lot of danger in terms of appeal and remand, because what you're talking about is whether or not to grant still more process, and there's usually very little prejudice or downside to giving more process. There's only an issue with if you short side somebody. So for what it's worth, it's not a recommendation, but I wanted to at least give some boundaries to the discussion in that regard. Thanks.
Thank you. Commissioner Bozievich and then Commissioner Buck. You had your hands up at the same time.
Yeah. I've spoken before. If you want to go to Commissioner Buck first, it's up to you. Okay. I was going to kind of make one of the points that Andy sort of made. The letter from ODF, the original one, was dated April 29th. And then they followed up with a second letter on May 18th. That's not too far ahead of when the applicant had to make final rebuttal. I think, I'm not even sure whether the record was closed by May 18th or not. I have to go back and look at dates, but it was really late in the process that ODF stepped in and kind of grade up whether or not the applicant had demonstrated whether they had a significant impact by saying they did have a significant impact, and then two, offering to work on a mitigation plan. I believe that's late enough in the process and all that it deserves the ability for the applicant to work with ODF and address that. That's why I seconded the motion, and I feel it's a good thing. And yes, the longer decisions take, people do have anxiety about it. But I would remind folks that Springfield's lived with a quarry adjacent to it for how long? I'm sure Chair Bernie's pretty well aware of the quarry that sits between Doris Ranch and basically the Agnes Stewart Middle School. They're just right up against the Willamette River. Sound familiar? For how many years? And I don't think Springfield's exactly gone to the heck in a handbasket because that quarry is there.
I'm sorry, Commissioner. We're getting feedback. It's hard to hear Commissioner Bozievich.
Yeah, that's not coming from me. I don't think.
There you go.
Yeah. So I just want to say, understanding that Springfield has survived a quarry adjacent to the city, I hope people can look at that and say it's not as bad as maybe people are being led to believe. If it is even approved, reopening the record doesn't guarantee they're going to get approved. It only gives the applicant the opportunity to get approved.
Thank you, Commissioner. Are you okay? Yes, Commissioner Buck.
Thank you, Chair. We got the ODF and W letter prior to us closing the record, and that would have been a good time for the applicant to have asked for additional time to go through this process. So for me, it kind of feels like, well, we got the ODFW, we close the record, oops, we want to address it, but now we have to re-ask for opening the record again. It doesn't feel fair to both sides of this particular process. And for that reason, I'm leaning not to reopen the record. One other point I really want to make is, had LUPA done its job in the first place and not just remanded on a notice and been able to go through each of these items specifically, they could have come to a conclusion for this entire applicant and the community by this point. For me, that's still a large source of frustration from the LUBA decision-making body. This gets really technical really fast with each one of these items that's presented in front of us. There have been lots of conversations about things that we cannot consider in this particular moment. And it is very limited in this point. It's very technical. And that's why we have thousands of pages in front of us. I really feel strongly that they should have done their job in the first place. And part of this process here today, depending on what we decide, could require them to finally make a decision on this. Thank you, Chair.
Thank you, Commissioner. Are there any other commissioners that would like to weigh in on this discussion before a vote is called? I guess I would just like, it's really interesting. I wish this wasn't an us versus them, you know, one side versus another. I don't mean within the board. I just mean in terms of the issue, one side versus the other. And we all have different opinions. Like I said, I voted enthusiastically when Commissioner Bozevich had more direct access during a vote. No, I'm just kidding. I voted very enthusiastically to change zoning to allow for a local quarry for the very reasons that Commissioner Bozevich just articulated earlier. So this is not a quarry versus non-quarry thing for me. It relates to the criteria we're given. And for me, it also relates to this. The applicant, after the letter from, what is it, ODFW? Whatever it is, Fish and Wildlife. After that letter came, before we closed the hearing, the applicant stated to this body that they had already provided sufficient evidence in the record to approve. And so I go back to the staff recommendation based on the evidence recommending not approving. And for me, that's the linear thinking I'm trying to follow through here. So that, for what it's worth. And I don't think this will be the last we hear of this regardless, but Commissioner Farr, Vice Chair Farr, I believe, I see no other commissioner hands up, so I believe it's time for me to call the motion for a vote. It has been moved by Vice Chair Farr and seconded by Commissioner Bozevich. I'm flashing between screens. I don't have all the language. It relates to reopening this case. Commissioner Farr, if you don't mind, would you like to restate the motion, please?
Thank you, Chair Bernie. And I will say that the motion is verbatim in the board packet under option 2, and there's move to reopen. Move to reopen the record for the purpose of accepting a draft habitat management and mitigation plan to be submitted on or before a date specified by staff, by the applicant. After the draft habitat management and mitigation plan has been submitted, reopen the record until a date specified by staff to allow for the submission of response testimony. Notice I paused there to allow for submission of response testimony to the draft habitat management and mitigation plan and set a fifth reading for deliberations and a tentative decision for a date specified by staff.
I've really imposed on you, Vice Chair. That's the third time you've read it, but thank you very much. That has been moved by Commissioner Farr, seconded by Commissioner Bozievich. All those in favor, please signify by saying aye.
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 All those opposed? Aye.
Nay.
Okay.
The motion fails 3-2. Vice Chair Farr and Commissioner Bozievich in the minority.
Thank you, Chair.
Do we have a motion as it relates to staff recommendation, or is that necessary at this point?
If I, Andy Clark again, I think the board.
Mr. Bozievich is shaking his head. Yes, it's good enough for me. Go ahead, Andy.
There's more deliberation to do, I guess, is where we're at. The only thing we've decided is that you don't want to reopen the record. There's still 4 items identified as conflicts, and what staff will need to do, whether the board's decision is to approve or deny the application, we need to put down in findings the reasons for the board's decision. And that's why we need deliberation, so we can talk about what your particular views are with respect to all of those things. So, and there, even though staff has made a recommendation about big game conflicts, that's just a recommendation. We really need the board to decide each one of those issues. Obviously, the applicant has made arguments as to why, even without the mitigation plan, that the identified conflicts have been minimized. And I think the board needs to consider the arguments for and against, and give us some sense of where you're going with all those conflicts.
Do any board members wish to speak to what Mr. Clark just identified? Commissioner Buck?
Another process question, do we want to go through each individually, or we just want to pick out the ones that we want to speak about here? I guess it depends on how much conversation we all want to have.
Commissioners, at this point, I can tell you my only concern relates to the big game habitat conflicts that I've read from the staff report. There are 4 areas that were addressed by the supplemental cover memo. That's the one area I'm familiar with and have concerns with. I don't know if any other commissioners want to provide any other direction as it relates to Mr. Clark's request.
If I may, this is Amber Bell. It's at the discretion of the board to proceed with the full staff report, but if you would like to, I believe Deanna Wright has a full staff report prepared that provides an analysis of each of the 4 remaining issues.
Thank you very much. Commissioners, I think we're going to hear the rest of the report now. Deanna?
Yes, sorry, bear with me. I'm trying to bring up the PowerPoint again. So the key issue and dispute on the big game habitat conflicts are what you're seeing as the dueling expert testimony. And again, I'll note that the big game habitat conflict minimization is difficult because it's just wide open for discretion. It's a bit of an open book because there's no federal or state standards that indicate when the conflict is significant or no longer significant, such as for other conflicts like noise or dust. The applicant's position on this is that the conflicts are minimized via conditions of approval 21 through 24 and number 50. They also state that ODFW testimony does not demonstrate that big game conflicts have not been minimized. The applicant believes that ODFW comments speak to other types of wildlife not listed on an acknowledged list of significant resources. The ODF comments are outside of the 1,500-foot impact radius area. That the applicant has provided an ESEE in the event the board determines that conflicts with big game have not been minimized. And finally, that testimony from the opponent's consultant, John Goodall, improperly relied on studies conducted for a different subspecies of elk and not Roosevelt elk, and did not address the specific items such as habitat types or conditions on the subject property. ODFW comments further state that additional discussion with the applicant and mitigation measures are necessary, that the applicant's proposed conditions of approval don't adequately address the concerns of displacement and related habitat loss, and for conflicting uses that cannot be minimized, the department recommends mitigation for the loss of habitat. And finally, the department has not had the opportunity to review the reclamation plan. I'll also add that the letter from the opponent's wildlife biologist, John Goodall, his letter appeared to be just more general in nature and concluded that elk are generally highly sensitive to human disturbance. And that was submitted from the opponent's attorney, Sean Malone, and it was raised in the first remand. Key issue number 2, silica dust and air quality conflicts. The applicant believes that potential emissions and impacts are proposed to be mitigated through conditions of approval 28 through 33, 24, 44, and 49, and best management practices conditions of approval 51 through 54. Staff note there does not appear to be expert rebuttal testimony or evidence in the record undermining or calling into question the applicant's expert testimony regarding these conflicts. Number 3, conflicts resulting from groundwater vibration caused by blasting. LUBA sustained this issue and the applicant submitted additional testimony from 2 experts. The applicant's proposed conditions of approval 56 and 58 speak to this. There does not appear any expert testimony rebutting the applicant's expert testimony in this item. And finally, number 4, Gopa groundwater impacts. LUBA remanded this issue limited to groundwater impacts and quality centered on the berms and the stormwater impacts near the former Dunning Road landfill. And the applicant believes by adopting a revised figure 6 and corrected condition of approval number 8, the applicant's requesting that the board find that conflicts are minimized. So this is my last slide for my staff report. Regarding the option of tentative approval, staff does not recommend this option at this time because the remand item of conflicts to big game habitat appear to have been called into question as to whether the conflict is reduced to a level that is no longer significant. Regarding the option of reopen, sounds like we just went through that exercise with the board. Lastly, regarding the option to deny, staff believes the record does not have sufficient evidence to get to a positive finding for conflict minimization for the big game habitat goal 5 item at this time. Again, this is due to the comments provided by ODFW, the leading wildlife agency that called into question the big game conflict. And note, if the board does choose to deny, then staff will need to make specific findings as to how the conflicts have not been minimized, as Andy alluded to earlier. Findings will also need to include an ESEE analysis explaining the ESEE consequences of not allowing mining at the site based upon evidence in the record or lack thereof. So absent an ESEE could be grounds for a LUBA remand. As such, at this time, staff is recommending a denial With any of the options above, staff would need to return to the board with a 5th reading. This does conclude my staff report at this time. I'm able to answer any questions should they arise.
Thank you very much, Ms. Wright. Discussion, motion. Commissioner Bozovich.
A question for Ms. Wright. The 1,500-foot impact area that the applicant notes that ODF is basing their impacts going beyond, is that 1,500-foot impact area a criteria set in state law and our code, or is that something that ODF can look beyond and assign to this particular application? I'm trying to decide, is the applicant's part of their rebuttal that ODF went beyond what they're allowed to look at by going past the 1,500 feet? Is that a clear-cut criteria as part of what we're allowed to look at, or are we allowed to look beyond the 1,500-foot impact area?
I can weigh in, Deanna, if you want to take a minute.
I'm trying to find the OAR citation right now, so just to read it verbatim. It's subsection 5D. The criteria is like pages long, so bear with me. And Andy can chime in right now. He likes, while I try to locate this.
I'll summarize what hopefully you're going to read, and hopefully we get this right. But in general, when you have these aggregate mining applications are governed by the rule that Deanna is looking at, and one of the specifications of the rule says that when you are evaluating the conflicts, which is what we're doing now, you look at an impact area to see what sort of conflicts might occur within that impact area, and that impact area is 1,500 feet from the site of the excavation. It's possible for the board or the decision maker to, I should say that 1,500 feet is the presumption. That presumption can be overcome if there are facts and evidence indicating that there are conflicts beyond the 1,500 that need to be evaluated. In this case, this is the second remand. And so the 2 earlier board orders identified 1,500 feet as the impact area, and there had been no, at least affirmed challenges to that. And as I understand it, my position is that is not an issue. That is evaluating the question of whether we should look beyond 1,500 feet, I think is not before the board on remand because it was not challenged earlier. And that, I think, is part of what the applicant's representative had argued a little bit in the rebuttal, that ODF and W is talking about conflicts that occur beyond the area that the board should be considering.
I guess my follow-up to Ms. Wright on that is, does she agree with the applicant that ODF's considering beyond the 1,500 feet, which is not currently in question?
So it does appear that ODFW comments may be beyond the 1,500 feet radius area. Furthermore, a few objectors did raise the issue of the analysis area needing to be beyond that 1,500 feet. And like Andy said, through our review of the LUBA remand, this is the first time we're hearing about it. It does appear that this issue is outside of the scope of what can be considered by the board in this remand. But yes, the Oregon Administrative Rule in subsection 5A does limit it to 1,500 feet. And it says, except where factual information indicates significant potential conflicts beyond this distance. But there again, in the LUBA remand, it did limit it. I mean, it didn't really speak to it. So that's why in the staff report, we stated the issue appeared outside of the scope of what can be considered by the board today.
Okay, or no?
Yeah, I'm good. Sure wish we had reopened the record so we could clarify this.
Thank you, Commissioner. Commissioner Trieger, did you have your hand up?
Thank you, Chair. And lots of things competing for what's going to come in first. I think first what I want to say is I want to clarify the statement I made earlier. You know, whatever happens, we have to ensure whatever decision we make is legally defensible. So we are relying on our staff attorneys in particular, as well as the staff technical expertise. And this is what my comment was in reference to, that the full circle of technical expertise, experience, background, and whose job it is to ensure we have a legally defensible decision is what's important to me. And so I really want us to be able to trust and rely and lean on staff, that they're guiding us through the possible processes here. And this is what my statement in its totality was reflecting earlier. Just like when we discussed before about the silica dust and wind speed and direction, you know, that's not in our control. And significant impact, to me, the word significant is the operative here. So if we're talking about impact, big game impact, and whether it poses significant impact, that is a subjective term. And this is where I circle back to share Commissioner Buck's frustration. You know, the length of this process makes the complexity of it clear, and the challenge of having this body make a land use decision when rather than LUBA having done this work to begin with. So I'm still really wrestling with this. As I recall, but I'm sure this is exactly what this process will lead us to, the conversations were around the impact of the elk within the 1500, but how that will then impact private lands outside of that 1500. And I'm not completely clear if I'm remembering that right, or if that is something within the scope, because it both lives within the elk living within the 1500 zone, but that then they have an impact outside of that zone. So that's a little bit of a gray area for me.
Thank you, Commissioner. Are there any other statements? My understanding, correct me if I'm wrong, I know you all will, is that because this body voted to deny the reopening of the hearing, we now need a motion to deny based on something, whether it's the big game concerns as articulated by the Oregon Department of Fish and Wildlife. But we need that to move forward, and we are not, sadly, at a time where if there's gray area, you might not want to, you might consider that in your vote here. But we need a motion to move forward one way or the other. Commissioner, I want to call on Commissioner Buck, but your hand was up first, Commissioner Bozevich.
Thank you. I just wanted to clarify, we actually can make a motion to approve if we determine there is sufficient evidence in the record that all four of these criteria have been mitigated, and that's available to us too. Just want to make that clear. We do not have to make a motion to deny.
Thank you very much, Commissioner. You are, not only are you correct, but I'm getting voices from on high that say you are correct. We can make a motion to either approve or deny, but we need a motion. Commissioner Buck.
Thank you, Chair. To move us along, I'll make a motion. I'll move to deny the application and direct staff to prepare an order on findings for final action with the appropriate SE analysis regarding big game as outlined by the staff report of not allowing mining. And this is for ordinance PA 1385.
Thank you, Commissioner Buck. Is there a second?
I'll second.
Commissioner Buck has moved and Commissioner Trieger has seconded a motion to deny, I'm now reading here, to deny, Commissioner Buck, tell me if I'm reading wrong, to deny the application and direct staff to prepare an order and findings for final action with an appropriate ESEE analysis of not allowing mining. Did I state that correctly?
Yes, I just added based on the staff report finding on big game or recommendation on big game.
Thank you. Is there discussion to the motion? Commissioner Bozievich.
I just want to note why I'm going to be voting against this motion. First, I do believe that if we're going to ignore the request for an extension of reopening the record, based on the current record, I believe within the 1,500 feet, the applicant has met burden of proof when it comes to big game habitat mitigation. So therefore, I can't support the motion to deny based on that. I really wish we had reopened the record because I think it could have clarified that. But right now we are set at 1,500 feet. And based on that, I believe they've met the criteria. And just to remind folks, we actually closed the record on this when ODF sent their second letter. The record was closed at that time. So we missed an opportunity there, and because of that, I have to vote against this motion. And I believe it's going to be appealed and cost us more staff time when we could have probably resolved this through a negotiated process between ODF and the applicant to come to a much better solution. But we'll spend time on appeals and cost a lot of people more money and more staff time. We do get fees for those appeals. Mind you, the applicant has paid a significant amount of money to this county so far to process this. It hasn't been a waste of staff time. They've been paid for it.
Thank you very much, Commissioner. Commissioner Farr.
Thank you, Chair Bernie. I'll just state why I'm voting against it, simply because we did not allow the applicant to respond fully to the conditions established by the ODF&W, and a process was in place. The tiny amount of time, the relatively tiny amount of time it would have taken for that to take place, really should have been, we should have allowed that amount of time. I'm voting against this for that reason.
Thank you, Vice Chair. I noticed, Steve, you're here. Mokraheisky, did you want to say anything or no?
The one thing I'm checking on is whether or not we need a roll call vote for a denial. So it looks like we do not need a roll call vote for the denial. So you can just go ahead and take the vote whenever you're ready.
I request a roll call vote.
This is Andy Clark. Let me just clarify. And that request by Commissioner Farr, I think, is fine, but I just want to clarify that typically an ordinance approval requires, of course, a roll call vote. This, if it's a denial, wouldn't be an ordinance, it'd just be an order to deny. So the roll call vote is as requested rather than as necessary by the charter.
Forgive me, technical question. I honestly don't know. So can any commissioner on any item request a roll call vote, and then will that then yield a roll call vote? Is that how that works?
The answer is yes, under Mason's rules. We don't either really adhere to Mason's or Roberts.
Okay, I wasn't stating that in objection, Commissioner Vice Chair Farr. I just didn't know. Are there any other discussions to the motion?
This is Staff Deanna Wright. So if we're headed towards a recommendation of denial, then I just wanted to put out there again, and Andy, you mentioned this earlier, if we're getting to a denial, then I'm going to have to make specific findings as to how the conflicts have not been minimized. So it would be helpful if I had like a little bit more specific direction, I think, from some of the board members as to why they're recommending denial on how the conflicts have not been minimized. And Andy can chime in here to maybe explain this a little more clearly.
Yeah, my understanding is that the motion that's been made to be voted on is that the denial is essentially follows the recommendations in the memo which would be to deny based on big game conflicts for the reasons specified in the OF&W letters, but that the other conflicts identified, that the board has found those to be minimized and such that those wouldn't be grounds for denial. And if that's the case, as I said, that's my understanding of the motion. If that's the case, I think we have enough to go ahead and draft up findings based on those documents. What we would do is essentially you would have, this would be a tentative vote to deny with instructions to come back with that order and findings such that you could make your final official vote on those documents.
Forgive me, I'm just going to say it's as clear as mud, Mr. Clark. Just one moment, Vice Chair. We've had today one staff say the recommendation is this, another staff person say the recommendation is that. We've had a real lack of clarity, and it's my presumption that this will be appealed. I think the commissioners Bozievich and Farr make great points, and I don't want anyone, mostly them, to think that I disagree with them. I'm going to reiterate. We were told, and this I think relates to Commissioner Bozievich's point that we could have had a motion to approve. We were told by the applicant they had sufficient information to move forward with this. And we were told by staff there was insufficient information to move forward as it related to the big game concerns expressed by the Oregon Department of Fish and Wildlife. So I'm voting on the basis of that, but this has been very difficult and somewhat ambiguous. Commissioner Farr, I'm sorry.
That's fine, Chair Burnett. This is a process. Mr. Clark is suggesting that staff come back with the wording of the actual motion. I prefer that the maker of the motion give us the wording, not that staff subsequently give us the wording. Let's just get the wording to the motion right now. Why are we denying? Let's hear it.
Commissioner Buck, you can respond. I could respond too, but if you want to.
Sure, I'm just going to say it's exactly what Annie Clark just mentioned. That was the intent of the motion, and that's what my motion was based on. It's going to come back no matter what to us for a final vote.
Then, Mr. Clark, you got to say again what it was you said, because I'm not sure exactly why we're denying.
Well, I can attempt to recapture the motion again, but I guess there's always in these board approvals, at least with complicated cases, the practical difficulty of identifying in the midst of a board meeting discussion exactly the reasons for the decision, especially when there are all these pieces flying around. So I can't tell you exactly. I think using the board memorandum, the agenda cover memo, as the basis for this board's denial is sufficient, because it gives sufficient detail to allow staff to craft specific findings that capture the decision. And then, as Commissioner Buck indicated, when this comes back to you for final approval, you can read all of the specific details and make your final decision based on that. Or, frankly, you can look at the details, and a commissioner may decide to say, no, that's not what I intended, and switch their vote. That's why today's vote is tentative only and not final, in my opinion.
And Chair Bernie, thank you, Mr. Clark, for that. That puts it pretty clearly that we don't really know exactly why we're denying. We're just denying, and we're asking staff to tell us why we're denying. Thank you.
I'm going to politely disagree with that, but Commissioner and I'll come back to that, but Commissioner Bozievich has had his hand up.
Thank you. So once again, I'm going to step in procedurally and remind folks of how land use actually works. We do it by ordinance. One of the reasons why you specifically state findings in the motion is if you don't and staff has to write those findings, we are due for 2 more readings. because it is an ordinance. It has to be read in its exact language 13 days before the final vote, which is one of the reasons why, usually if staff is recommending something, there's attached findings with it to be read at the time the motion's made, or at least referenced at the time the motion's made. So technically, we should be approving a reading and to deny with findings, and then go into that. But we'll have to do that at the next meeting if the motion stays the way it is. Just to kind of remind folks of how it actually works. This is an ordinance. We approve these kind of actions by ordinance. We have to have the exact language in 2 readings.
If I can comment real quick.
Only after I do. Thank you very much, Commissioner. Yes, Andy.
Okay, sorry. Just because I want to respond directly to that. I would agree with Commissioner Bozovich if the board's decision was to approve the application, because the approval would take the form of an ordinance, and that's because our rules require an ordinance to make the comprehensive plan change that this application calls for. If in the event of a denial, there wouldn't be an ordinance to deny, it would simply be an order to deny the application. So we wouldn't need to do yet another reading, but we do need to make sure that what the board is approving and voting on is what they intend to. And that's why we need time to craft the specific language to make sure we're capturing the commissioner's desires. And that takes a little while. That's why we can't do it today, for example.
Thank you very much, Mr. Clark. So if I may, I know this is really enjoyable, but we do have an executive committee session that was scheduled at 2:30. My understanding is we have Mr. Clark, correct me here, we had a tentative motion. Is that what you called it?
Yes, a motion for a tentative order to deny, yes.
Thank you. We have a motion for a tentative order to deny. That motion is based on the concerns for big game habitat as expressed in the letter by the Oregon Department of Fish and Wildlife. We have a request for a roll call vote. Is there any discussion before we take the vote? Because this will appear before us again, not as a motion for a tentative, but as the motion. Yes, Vice Chair Farr. Yes, sir.
Well, what Mr. Clark says is exactly accurate. That is option 3. So it is a motion to direct staff to prepare an order and findings for final action with appropriate ESEE analysis. So I think we're on good standing as far as the process is concerned. I have no objection there.
Thank you, sir. Is there any other discussion before we take a vote? Do commissioners have any objection to entertaining Vice Chair Farr's request for a roll call vote? Commissioner Trieger.
Thank you. I'm just curious the purpose, since the public record shows each individual vote regardless. So I'm just genuinely inquiring.
Commissioner Farr.
Well, it goes back to my legislative days when it was called for quite often, because it is in order that for people's actual vote to go on record so that no question can arise in the future, such as a question arose on one of my votes earlier in this board's meeting process, so that it's very loud and clear where the vote lies, that there's no ambiguity.
So Commissioner, if you have an objection, but yes, you're right. Either way, it would be very clear how each commissioner voted. May we have a roll call vote? Steve?
Yes. So on the motion to deny the application and direct staff to prepare an order and findings for final action, Commissioner Buck?
Aye.
Commissioner Bozovich?
Nay.
Commissioner Trieger?
Aye.
Commissioner Farr?
No.
And Commissioner Burney?
Aye.
So the vote is 3-2 with Commissioners Bozovich and Farr in the no.
Thank you very much. I
Chair
don't
Bernie,
know. Yes.
sorry, going to interrupt you once more and trouble you with another request. And that is to have an additional motion for another reading. And I know that sounds weird, but 2 points. One is we need a date to come back to you with the order and final documents. And additionally, the way to keep an ordinance alive is to keep doing readings. And if we skip a reading, the ordinance is dead. In theory, that's fine if the vote is, of course, finally to deny it. But on the off chance that one of the commissioners who wants to deny the application switches their mind and wants to approve it, then we still have a live ordinance to do that. And so my convoluted request is a motion to set a fifth reading at a time or a date that hopefully Deanna can give us, because I can't remember what calendar she was thinking about.
Well, either we look at various calendars and ask Diana Jones when we can do that, or we simply identify a staff to be determined, date to be determined. How can we do this so that we can wrap this up, Mr. Clark?
This is staff Deanna
Chair
Wright.
Bernie,
That October 26th would be a feasible date for us to put a order together with findings and an ESEE for tentative vote. October 26th would work.
Thank you, Diana Jones.
Chair Bernie, this is Diana. October 26th would work for that item. I'm assuming it would be a 1:30 p.m. time certain.
Thank you. Well, if that's necessary, would someone make the motion? Commissioner Buck.
I'll work on it. So we're, just to be clear, approving the fourth reading, setting the fifth reading, and deliberations for ordinance number PA 1385 for October 26th, time certain at 1:30.
Is there a second?
Sorry, I'll second.
And thank you, Commissioner. It's Commissioner Buck has moved and Commissioner Trieger has seconded. I'm sorry. I can't articulate all of that. You did good, Commissioner Buck. Would you repeat one final time the motion? I'm sorry.
Sure. Approving the fourth reading and setting the fifth reading and deliberations for ordinance number PA 1385 for October 22nd, time certain at 1:30.
Thank you. All those in favor, please signify by saying aye.
Aye.
Opposed? And the motion for the fifth reading is scheduled October 26th, 2021, has been approved. I believe, Commissioner Bozevich, did you vote on that?
Yes, I voted aye. Because
Okay,
I had to
thank you.
continue the readings of the ordinance. I think I was trying to point that out.
You were, I just didn't hear the vote. It's approved 5-0. You did point it out, sir. Okay, are we released, Mr. Clark, or not yet?
That's all I have, Chair. Thank you very much.
Thank you so much. And thank you, Ms. Wright, very, very much.
Thank you.
Thank you, commissioners, very much. Okay, we have executive committee, but before that, Commissioner Business 14A, are there any announcements from any commissioners? Seeing none. 14B, are there any future board assignment requests? Yes, Vice Chair Farr.
Thank you, Chair Burnett. As I telegraphed earlier in the meeting, I would like to request a work session on the statutes and codes concerning the placement of tiny homes. We'll just call them tiny homes as a general category, specifically in the Holiday Farm region.
I believe we need, is there any discussion before I ask for head nods? Commissioner Buck?
I just want to say that I enthusiastically support that idea. We, as Commissioner Farr and I, or he mentioned earlier, we had a discussion over this, and this is a great need, not only in the Holiday Farm fire, but all over the county. But this is a great way to start off the conversation.
Thank you.
Any other discussion? For what it's worth, Commissioners Farr and Buck, I could not agree more. Are there head nods? Yep, we're good. We're good. Okay. Anything else, Commissioner Farr? Is that it? Commissioner Trieger.
Thank you so much, Chair. As I mentioned earlier, I have 2 items. The first is at our JEO, at our Joint Elected Officials meeting, there was discussion and updates on work on progress toward on the TAC report. And we heard some excellent updates from staff on work alongside some concerns, both from some city electeds and at the county, as to whether this plan is maybe due for some modifications or a refresh, given the many contextual realities relative to the several years ago when the plan was originally, or the report was originally produced, including but not limited to the pandemic, displacement by fires, equity focus at the county, and more. It was also noted by several of us that given several years have elapsed since data was initially gathered and the report was published, I heard some concerns, not about the ultimate goals of the TAC report plan, but specifically more about whether we're working with the right set of strategies, metrics, and data points, and if we have all the right jurisdictions engaged that we need to. It was also raised that the plan doesn't address the capacity to deliver on the strategies, both in terms of our community-based organizational partners and our own organizations at the city and the county. So I'm asking for head nods to simply direct our county administrator to work with the Eugene City Manager and do an assessment as to whether the TAC report is still on track or needs any modifications or adjustments, and bring back some recommendations for any changes or updates that they might have to just help better align the plan with the current conditions on the ground.
Any discussion on that? Vice Chair Farr.
Just a question, and I'll ask Mr. Mokrasky. Did that seem like an agenda team request or a staff direction?
I heard the request is asking the county administrator to work with the Eugene City Manager to review the TAC report and any needed changes. So I heard that as an assignment.
Okay, all right.
And that was my intention, to just ask the 2 managers or administrators to give it a look to see if they want to bring any recommendations back to us, which then would be something we could look at, or their recommendation might be that the agenda team puts it on a work session. I just thought that was the right place to start.
Perfect, thank you.
Yeah.
Are there any other comments before a head nod request? I have a request, Commissioner Trieger, and it is entirely your right to accept this or not to accept this. But is there any way that we might include the Springfield City Manager with that group in evaluating, assessing, or would you prefer the request as you made it?
I think based on what I heard at the JEO, and my understanding is because the plan exists as a City of Eugene and Elaine County plan currently, that and whether those are still the right players, that's the initial assessment should be, are those still the right players? If the recommendation comes back that we should bring other jurisdictions in, Springfield or otherwise, then that's one of the suggestions or recommendations for us to consider. But it's really to take the plan as it currently exists, as it was drafted with the agencies that have been with the project from the start, to give it that look about what, if any, kind of refresh or modifications are needed.
I tried. Okay, thank you. Are there 3? Yes, Commissioner Buck.
I'll just say that I can't see a situation in which that doesn't come back with a recommendation to include Springfield and other surrounding counties or cities and unincorporated areas that really want to be a part of the conversation.
Well, let me just say, and trust me, I'm not trying to beat a dead horse here, that to me, I agree with you, Commissioner Buck, and I'm fine with your request, Commissioner Trieger. I just wanted to say that for as long as we don't hear other voices, looking at reevaluating a plan, we just don't have those voices to benefit from. And Commissioner Trieger, before you came on the board in these meetings, when I requested that the city of Springfield participate in this, the answer I received was they didn't help pay for it. They're not participating in it. I think it's evolved since then, and that was very clear at the JEO meeting. And I felt kind of bad. I didn't mean to make such a strong statement, but that's the only reason I asked, but I'm fine. Yes, Commissioner Farr.
Thanks, Chair Byrne. And I will point out that Springfield has been completely immersed in the tech report from the beginning, even though they did not participate in paying for it, because they are on the Human Services Commission, and we do talk about the tech report. They are on the Poverty and Homelessness Board, which is a multi-jurisdictional, not intergovernmental, and we do talk extensively about the tech report. And Springfield is present at all of the subcommittees of the Poverty and Homelessness Board. So they're there. It's just a matter of, I think, Joe, kind of formalizing it and make sure that they know that that we view them as an equal partner in the process. Thanks.
Thank you so much, Vice Chair. And whoops, I was about to get the head nods, but Commissioner Bozevich.
I just want to state real quick, I support this request. A lot has changed since the TAC report was done. The full impacts of the Boise decision weren't really well understood. Measure 110 has changed the landscape out there. It's time to update this and understand where we are now versus where we were then. And even at the time we got the TAC report, there was some mysterious modeling in the background that they never disclosed of how they got to, infrequent and not happening so much for singles, and how many housing units and shelter beds would do that. And an opportunity to update that and relook at that and actually see how they came out with the recommendations they did versus this black box would be helpful for me.
Commissioner Trieger.
Thank you, Chair. And just to be clear, to bring it full circle before we get head nods, I'm really, and to give some more clear direction to County Administrator, I'm really asking for a very high level sort of look at what are the key issues that seem to surface in this relook to bring back to us for more conversation. So again, that may be other jurisdictions, Springfield, and then some. It may be the data that we collected. Do we have the right data? Did we use the right methods to collect it? It's really more that high level look at what are the issues with the report that we might want to dig a little more into so that it continues to be a living guiding document.
So Commissioner Trieger, you're going to get the head nods. So what I wanted to do is mysterious modeling to the side. I wanted to add on to some of the things Commissioner Bozevich mentioned. There are also a couple of little things that have occurred since that report was written, like COVID, like the worst natural disasters we've ever seen that have created additional homelessness. So I couldn't agree more with every commissioner's comment. Having said that, are there thumbs up?
Thank you. The second item, much briefer. I'd like to request that we call an executive session to discuss real estate concerns involved with the potential relocation of the Lane County Historical Society Museum, which is currently located on Lane County property at the fairgrounds.
Commissioner, would you like to give us any more on that, or is that all we need right now?
And that's all I need. If folks want more to go on in determining whether to make head nods, but they published in their latest newsletter, which that they're looking at other property. We've discussed here as a board the inadequacy of that space for their ongoing needs, which means there's conversation for them because it's a long-term project to consider relocating and finding the right home. And since that could potentially be a real estate transaction, since they're located on county property now, I'd like us to discuss that in an exec session.
Any discussion before a call for thumbs ups? All those in favor, just thumbs up if you would.
Thank you.
You're on a roll, Commissioner. Are you sure you want to stop now? Okay. Is there any other future board assignment requests? Commissioner Bozevich.
Thank you. I informed the board last meeting about the shortfalls that we were looking at in the Public Safety Coordinating Council Budget Committee in our grant and aid support of our Community Corrections Act operations and in our Justice Reinvestment Grant program, various programs. These programs are one of the places we do restorative justice and do a lot of really good things in our community for a lot of people that are, have been in contact with the criminal justice system. Right now, it's looking like we would have to eliminate a significant amount of program and staff to balance that budget. And a lot of that deficit comes from the fact that we lost ground against the rest of the state in folks under supervision due to the COVID closure of our court system here in Lane County. And when I'm asking for the board to support to try and protect some of these critical programs, hang on to this staff trained in trauma-informed care and cognitive behavioral therapy, is to direct the county administrator to look at how he can find ways to close that gap that was caused by our reduction in percent under supervision for that, and to allow for the Public Safety Coordinating Council maybe to budget for that gap rather than start the process of eliminating positions. Everywhere from sponsors to parole and probation to the sheriff's department, there would be positions everywhere. And a lot of good programs and treatment spaces eliminated in our contracts with nonprofits like Emergence. So it's such a critical thing. It really fits, the impact caused by COVID so much, because we stayed under extreme conditions and extreme risk longer than a lot of other counties did for a lot of various reasons. That we were testing so much in this county was part of it. But this is a really critical issue, and I such important programs that this particular budget supports. I really hope that you can support asking the county administrator to work with staff to try and find a way to fill that gap.
Thank you, Commissioner. Are there any, before I ask for head nods, are there any questions or comments or discussion? Commissioner Trieger.
Thank you. I have a question about how that's different. I mean, I understand the importance of that work, don't get me wrong, and I appreciate you bringing up the elements around restorative justice and the trauma-informed care that's delivered. But is this not something that would be addressed in our broader conversations about use of ARPA dollars, or is different than any other program or department that's experiencing shortfalls or constraints or challenges in delivering their services on their budget? What makes this different that we're pulling it out as a specific assignment in this way? So I just understand what I'm actually asking our administrator to do that isn't part of ongoing work at every department level to figure these shortfalls and service delivery goals out.
So part of what makes it different is the PSCC is required to submit a biennial budget by the end of August. And we basically have to make a lot of decisions really quickly. And I just want to impress that this kind of is jumping ahead of a lot of that. We're still in the process of getting staff on board to deal with ARPA. And there may be other ways to close this gap. I don't want to limit the county administrator just to those particular funds. It is definitely tied to COVID, why we've fallen behind and why we have this gap and why it's causing such a huge impact to the budget. But it's really driven by state deadlines to make our applications for various funds and how that all falls into play. And we are, as the PSCC budget committee, we have to make some decisions very quickly. It has to come back to the board. Actually, the PSCC budget is coming back to the board in August. for approval. So we're scrambling right now. And if I can get support of the 3 thumbs up and have the direction to the administrator, he can work with the PSCC budget committee to see what we can come up with to maybe close that gap and avoid some of these cuts at this time. But, it's sad though that we didn't get the full-time study funded, at the legislature. We did get some, I will have to thank the legislature at the last moment. They did throw additional funds in both these programs. It just really wasn't enough to pay the actual costs.
So if I'm understanding, the ask is not necessarily directing the administrator to figure out how to close that gap, but to bring to us any various scenarios for whether it can be closed or entirely, partially, or not at all, and if so, where those dollars might come from or when they might come. Is that right?
Yeah, I'm going to leave this kind of up to the administrator, maybe to make sure he qualifies that. I was directing him to try and to find a way to close the gap, but I guess I also want to have him have the ability to come back and say, you know what, we just can't do it.
Right, I understand. Yeah, and I do understand there's time sensitivity, both in terms of statutorily when your budget's due, and also just staffing. That's the real on the ground consequences. I get that. I just want to make sure I'm nodding my head to what I think I'm nodding my head to. And I'll cheat a little bit since I have the mic by just saying, because back in announcements, but since you mentioned thanking the legislature, there is a post-legislative session town hall this evening at Alton Baker Park outdoors with our Lane County delegation presenting on the session for anyone that didn't know that might like to attend 6:30 this evening outdoors at Alton Baker Park. Thank you.
Well, that was really cheating, Commissioner Trieger. And I'll cheat too. I'm moderating it. It's a long day. So Commissioner Bozovich, is your question simply to demonstrate that there is Board of Commissioners support for the request to see if Mr. Mokry-Heisky and his team can fill or mitigate that gap?
I guess that's probably a very accurate summary of it, because this is going to take more than 15 minutes of staff time. I can't ask for it personally. It needs at least three board members agreeing for the administrator to look at this and try and figure out a way to close this gap. I think there's a strong possibility of closing it using ARP money, but I don't want to put any more brackets around the administrator than I have to. I want him to be creative.
Well, if I may, I just don't know how to express how happy I am that you now are a little, grappling with exactly the thing in the way that many of us were at one of the earlier agenda items. But I think this is very clear, and my understanding also is that this isn't a demand. It's just a request with full board support. Is that correct? Mr. Mokry-Heisky, do you want to say something before I ask for head nods? Is there any other discussion on this? Head nods, thumbs up.
It's okay, everybody.
Very good. No, absolutely. Look, thank you. That's one thing. We're all in this together, and it requires all of us to be keeping our eyes on different pieces of this and to try to support each other whenever possible. Thank you, Commissioner Bozovich. Is there any other future board assignment requests? As much as I don't want to bring something up at this late point, I do want to let the board know that while there's no one more desiring in-person meetings than yours truly, and while my request earlier was for in-person meetings to start August 10th, and the board determined August 31st. And while Diana and her staff are going to be having a hybrid test tomorrow, which we will be participating in, the data is telling us something fundamentally different. So I do want to mention and make an agenda assignment request, really, that this is something that we're going to have to discuss as a group at our next board meeting. Okay, I just needed to point that out. And trust me, I don't want to point that out, but the science is the science. and the data is the data, as we heard earlier this morning. Are we good with that? Okay. Is there any other, no, there's not. Okay, Steve, it's yours.
So I have 4 assignments here. Commissioner Farr's request for a work session on codes and regulations regarding tiny homes, and I'll take that also just as ADUs in unincorporated Lane County, focused on the Holiday Farm fire, but throughout Lane County. I will say as a note that I had a conversation with Amber Bell and Kier Miller yesterday about that, and they were planning on doing a work session later this year on that topic, and then bringing some updates to the Planning Commission in late 2021 or early 2022. So that is work that is beginning to happen based on new legislation that's been approved by the legislature, but we certainly can have a work session to talk about that process and get feedback from the board. The first request from Commissioner Trieger to have the county administrator and to work with the City of Eugene city manager and other staff to determine the needed changes, any needed changes to the TAC report, high level look at that, and then bring back a discussion on that. The second request from Commissioner Trieger to do an executive session on Lane County Historic Museum, questions about land, the location of that facility and land issues around that. And then the request from Commissioner Bozevich to direct the county administrator to identify possible solutions to close the funding gap for various public safety system partners. I think I captured that. So we've identified folks. I've been working with Diana Jones to identify folks to lead each of those, and we'll take on that work and come back to you when we're able to accomplish it.
Thank you very much, Mr. Mokrahysky. You got it. At this time, it's 3:24. It's 3:24. We are going to need to move out of board meeting to executive session. Yes, Commissioner Farr.
Thank you, Chair Burney. If now's the appropriate time, I do need to make a declaration.
Diana, is now the time for Commissioner Farr to do that before or after you read us into executive session?
Before would be correct.
Please.
Chair Burney and Commissioner Farr, I just wanted you to know that the 2 subjects of the executive session are quarterly litigation update and the FAPO probation officer matter.
But additionally, to executive session for tomorrow as well, for the agenda for tomorrow, which does involve discussions around AFSCME.
Yeah.
Correct. We will be reading in for both sessions at this time. We will not be reading in again, so we will have AFSCME.
In other words, Commissioner Farr is absolutely correct. So please, Commissioner.
Well, I think Mr. Dingle and I are both correct, but in that we're doing 2 sessions. I'm never going to argue with Mr. Dingle in public. That being said, before we convene an executive session, I wish to publicly declare a potential conflict of interest pursuant to RS 244.020, because my son is a licensed qualified mental health professional who works as a psychoanalyst for LCBH and is a member of AFSCME and is a steward for that union.
Thank you, Commissioner. After Diana reads us into executive session, I'm going to propose that we reconvene in executive session at 3:40. Does that work? Okay. Please, Diana, if you would.
Thank you, Chair Burney. At this time, I will be reading the Board of Commissioners into executive session for Tuesday, August 3rd and Wednesday, August 4th. The Board of Commissioners will meet in executive session to conduct deliberations with persons designated by the governing body to carry on labor negotiations and to consult with counsel regarding the rights and duties of a public body with regard to current litigation or litigation likely to be filed. This executive session is held pursuant to ORS 192.660(2)D and H, which allows the Board of Commissioners to meet in executive sessions for the purposes listed. Representatives of the news media and designated staff shall be allowed to attend the executive session. All other members of the audience are asked to leave. Representatives of the news media are specifically directed not to report on any of the deliberations during the executive session, except to share the general subject of the session as previously announced. No decision may be made in executive session, and the Board of Commissioners reserves the right to come back out in public session should the need arise.
Thank you very much. We shall convene an executive session at 3:40. Thank you.